years ago in Wolf versus Strengthman. The Judicial Council clearly, they direct and administer the judicial branch of government in California. They're clearly a state agency, as the court in Wolf held. Cone, 2 years ago, did modify the test for 11th Amendment immunity in determining whether an entity is a state agency. It, as Judge Bumate indicated, Hess was absolutely addressed in Cone. But the factors identified in Cone, intent, control, the financial relationship between the entity and the state, those all clearly support the conclusion that Judicial Council is a state agency. Today, if the court does apply Cone, the Judicial Council is clearly still a state agency as it was 20 years ago.
Can I ask, this doesn't seem to be a textbook case for the Rooker-Feldman, because as I see the relief, it's not overturning the child custody decision, but it's for training. So doesn't this take it out of Rooker-Feldman?
Well, I think there is an argument that Rooker-Feldman does apply, because the underlying harm here is the allegedly erroneous child custody orders. And what's happening here really is an end run around it's rather than couching a direct attack on a judgment, it's an end run around that to go to the Chief Justice and try to hold her and the Judicial Council responsible for these orders.
It might be an end run, but it might take it out of Rooker-Feldman, though.
It may. I still do construe it as being an attack on the child custody orders, and I do see the fact that they are seeking damages here based on the alleged deprivation of appellants and their children.
So that might be part of Rooker-Feldman, but the injunctive relief might be taken out.
Well, I think that I think there's still the argument that it does apply. I understand again.
If it does, if Rooker-Feldman does not apply to the injunctive relief, then you've got the problem of redressability that I was asking a colleague about. That is, how does an injunction against the Judicial Council do anything for these plaintiffs?
Well, I agree with that. I think it sort of goes back to, typically in Rooker-Feldman, you have a final judgment. And so there's then a collateral attack going to federal court. But here, I think, as you're alluding to, there's still the ability to seek redress in the Court of Appeal, and directly for these plaintiffs to seek redress in whether it's reestablishing their custody rights or whatever the case may be.
Rooker-Feldman can apply to interlocutory judgments that are appealable.
Yes, this court has held that is the case. So I think that you've got the issues here of the extraordinary relief that's being sought here, trying to hold the Chief Justice responsible for allegedly erroneous child custody orders, which is not available. There is no Section 1983 relief for that. Judicial Council is clearly a state agency. It is not a person under Section 1983. It is also protected by 11th Amendment immunity.
Green, I've got a federal courts quiz for you here.
Okay.
And that is, there are a number of different issues that we could potentially use to address this case. Is there a sequence that you think we should follow?
I think probably, as I've outlined in my briefing, I think primarily Judicial Council is not a person under Section 1983. Tied to that is also 11th Amendment immunity. And from there, I think the other issue that's significant here is there's the failure to state a claim on this failure to train theory. Is that again, the proper course here is seeking relief. This is a supervisory liability type.
So can I ask if we reach the sovereign immunity question, why would we have to reach the person question under 1983?
You wouldn't. That would end. If there's no immunity, that's the end. Excuse me. If 11th Amendment immunity applies, there is no other ground need to be addressed.
I think we have some case law that suggests that sovereign immunity challenges are threshold questions.
That's correct.
Whatever that means, but
it would resolve the case, and you would not reach any other issues. So I think 11th Amendment immunity and whether state agencies not being a person under 1983 are kind of connected issues. They are independent, so theoretically you could address 11th Amendment immunity first.
Those are both waivable, though, aren't they? You haven't waived them, but
The 11th Amendment, absolutely, it could be waived
Yeah.
if we didn't raise it. If the state court case gets removed to federal court by a state agency, the state agency's waived it, but it has not been waived here. It was asserted on a motion to dismiss.
I'm just trying to distinguish between waivable and non-waivable subject matter jurisdiction, but that's the federal court quiz.
Right. I think in the 11th Amendment, in the instance where it was waived, which is not the case here, there still would be the issue of a state agency not being a person under 1983. I think that would still be a problem and an impediment to suing a state agency in federal court. Unless your honors have any more questions, I will conclude.
Thank you, counsel.
Very much.
Phillips?
I did want to say again that the plaintiffs in this case are not challenging any specific judicial acts, but rather a policy which has led to the abrogation of the Constitution in the state's largest court system. Writ relief is available, but again, my understanding is that there is no revenue to appeal a temporary order. And the temporary orders is generally how family court takes away children, is via temporary orders. Turning your honor's attention to the Wolf case, the Wolf case never cites Hess versus Port Authority. It never mentions the word state treasury criterion, and it never mentions financial independence test. And I also looked at the Cone case today, and I did a word search, Control F, and the term Hess never appears.
That is incorrect. As I read the case, it is discussed.
I mean, the Treasury factor, I mean, we might not have cited Hess by name, but it's been cited many different times by the Supreme Court, and it's definitely addressed
Okay.
in Cone.
And
I was in the Senate Cone, but I mean, I still think they got that part right.
thank you, Your Honor. And as to the Rooker-Feldman, again, there's not going to be, this is not a final state court judgment that we would see in a civil action where the wrongdoing is either found to have happened or the wrongdoing is not found to have happened. But rather, the whole idea of custody is a somewhat fluid concept as the children are bandied back and forth between the parents. And if an injunction were granted, I believe that the parents whose children have not aged out, the plaintiffs in this case, they would still benefit directly from it.
Can you
No,
point
they
us to
would
any?
I'm sorry.
Go ahead.
I was going to say, wouldn't they benefit, if at all, only indirectly? Because what you're asking for is training and not specifically overturning any particular order.
Well, I think that's true. Yes, I believe the training would benefit them, though. I think that would.
Can you point us to any precedent in which a federal court has issued an injunction to state courts telling them how to interpret the law, in essence giving them a lecture?
Well, not necessarily. Well, we're looking not necessarily to the courts, but the policymakers, if to the extent that's an important.
Precedent for that?
Well, I know that there's, I've seen many lawsuits with law enforcement when law enforcement officers have to be trained on Fourth Amendment.
About the courts, about federal courts treating state courts as junior partners or students.
Right.
Talking about the dignity of the states, and I'm just wondering if you can direct us to any precedent for comparable treatment of the state courts by federal courts.
No, I have no precedent on that, Your Honor.
Okay, you're over time. Anything you can wrap up? Okay, thank you very much. This case is submitted.